recognition for pattern is up to 10 years, some 15 years. And if you compare that with the post-TRIPS norm of at least 20 years, then you see there's that heterogeneity in the legal regimes. And of course, that poses a little bit of a problem. And of course, you can also look at it from the context of expertise beyond the IP institutions. If there are cases, for example, in terms of that are brought related to infringement and the entities are seeking redress, where do they handle that? If they go to the courts, how many IP lawyers are available within our court system to actually handle some of those cases? We still have a long way to go as far as that is concerned. And obviously, capacity issues prevail in that regard. We also then, of course, have the major issue of counterfeiting, which is actually a big challenge. And if you relate that to pharmaceuticals, it's a big challenge across the continent. And it is an IP issue. Part of it's awareness, part of it's capacity, part of it's a little bit more structural and deep-seated. And actually, at times, very complex, because then it has dimensions that span across interests, part of it corruption, and so forth. Then there's also the issue of within the continent, we have two entities that in the institutions that IP have a report for the English speaking. Then we have OIAP for the French. And there are a little bit of differences in the way then these entities deal with these issues. Now, if you think about that within the context of the AFCFTA, of course, then there is need for harmonization, and that probably will go a long way in ensuring that then even the heterogeneous legal regimes within the countries could actually be updated to support innovation, protect new ideas, and protect the maybe patents and so forth, and then foster interest and probably redirect resources towards investment that is nurturing innovation. And of course, in that way, we can be able to ensure that it actually fits into the rest of the economic sectors. So to me, if we look at all these dimensions, we can then pick out the gender-related aspects of them. And it is clear from the various reports that as far as IP is concerned, and whether it is in access, whether it is in terms of usage, or whether it is in terms of the patterns that are being reported, there are clear gender gaps in that. I think WIPO estimates about less than 17% of the reported IP patterns that are actually attributable to women. So that shows you a significant gap. So to me, I think this discussion will be quite instrumental in fleshing out some of these issues, and especially when we're thinking within the context of the AFCFTA, what does that mean? What does that mean for the entities that actually will heavily rely on innovation and would want to redirect resources towards innovation within this current environment? So with those few remarks, I'm happy to hear and first of all, wish the panelists that we have a very good discussion. And I'll be actually keen to hear all these insights and how they shape the agenda as far as IP is concerned. Thank you very much.
Thank you very much, Head of Center, for those opening remarks, which set the context of the discussion that we're going to have. Without further ado, I would like to call upon our first panelist. I will be introducing the panelists as they come so that I can save on time. So our first panelist is Tsotets Makong, who is the head of AFCFTA Secretariat's Capacity Building and Technical Assistance. He's also an adjunct faculty member at TRapca, Previously, he was a counselor for the Lesotho mission in Geneva, where he dealt with a number of issues, including IP. And it is an exciting moment, considering that also among the things that he's working on now at the FCFTA, he's been heavily involved in the IP protocol as well as the digital trade protocol. So Tetsi, over to you.
Thank you very much, James. And I should also thank colleagues from TRAPCA for inviting me to be part of this, I think, exciting session. And I will attempt to be a little quicker and give me a second to load the slides. And then it's not a mini slides, it's about, let's say, 4 substantive slides that I'll speak to. Right. Now, one thing that I wanted to talk about is the whole source code. I think we know very well that when it comes to source code, everything rises and falls on source code in as far as digital trade is concerned. But perhaps we have to look at it in terms of how it dovetails with intellectual property. The first thing that I wanted to impress upon this meeting of us is that we are seeing a lot of free trade agreements, of course, not the least, the AFCFTA digital trade protocol currently under negotiations, moving towards dealing with matters such as source code. So at the end of the day, we are seeing this as more of a laboratory whereby countries are trying to find best ways to deal with things like source code in the context of digital trade or e-commerce, as it were. Now, these agreements, what they are basically doing in a nutshell is to set the conditions for cross-border supply of digital services, as well as goods, as I must say, but also one which is a critical issue, and of course, this being one thing that I want to zero in on, is the treatment of proprietary assets. And here we are talking about intellectual property aspects of the source code. And I hope we can have a brief moment to discuss this. And lastly, what these agreements seek to do is to provide guarantees in terms of the conduct of transnational digital businesses. And this means that, you know, they are trying to find ways to deal with challenges that these big businesses like Facebook may have in terms of the functioning of the market. So they try to also deal with that. Now, when we look at the FTAs, they are seemingly seeking to develop a layer of protection. One of the ways in which they deal with the source code is to provide a layer of protection in as far as the source code of software is actually concerned. One way in which they do this is to prohibit governments from requiring 1, access, 2, transfer of the source code that is owned by either companies or natural persons. So we are seeing that as something that the FTAs are doing. And there are implications that we look into in as far as this movement is concerned. Now, in the context of this sort of a prohibition in terms of governments, you know, because governments would want to have access to a source code, and there are reasons for that, and we can maybe pick one as we discuss this slide. But these sort of a protection of the source code, they seem to move towards what I call algorithmic governance. So because source code is actually a built way of algorithms, and of course, an algorithm being a set of instructions that basically describe how a given software should actually perform the tasks. Now, the issue is there is someone who sits behind when they develop code and when they develop a software, and they give that software instructions as how it should actually behave, which is why if you log in your own, let's say, Microsoft Word, you are able to use Excel, you're able to use slide, all of these different, Microsoft Office, components. The reason why you're able to do that, it is because there are a set of instructions that that particular software respond to as we begin to engage with it. Now, those who develop these sort of instructions, like, for example, not so long ago, it was found in the US that certain source code in terms of their algorithms, they are designed in a way that they can actually filter and discriminate against people of African descent. So that means there are issues that are actually embedded within the source code that may actually go against societal norms. And therefore, when you say, for example, that you want to protect the source code, and this coming up under the free trade agreement, the issue is that, do you also have an opportunity to deal with issues such as discriminatory practices that are embedded in the software themselves, at least in terms of their algorithm? So issues that arise are about algorithmic transparency. The second thing is algorithm accountability, as well as the issue of having to audit the algorithms in order to ensure that those inherent discriminations are not part and parcel of what makes these type of algorithms. So you can see already this point that I'm raising is against the point above that says source code has to be protected, but you protect it at what cost? That's a question that is actually being discussed, considered at the moment by those who are engaged in a digital trade and trying to find ways to deal with it. There is therefore a tension between protection of source code on one side and also holding developers and proprietors of the source code, and these, of course, operating on a transnational basis, trying to hold them accountable. So there's that particular tension. And let's look at then the IP aspect of it. And after this, hopefully we'll have a critical, a good conversation around this. Now, with that, the concern from an IP perspective is that the use of registration, certification, approval procedures by government bodies. So, for example, if you have the source code, governments may want you to, undertake certain registration, certification, or approval procedures. And therefore, if that is the case, meaning that if we say that governments want to have access to the source code, now the challenge with that is it means that the source code, which is basically sensitive to businesses because they make money through the code that they have. They make money through those instructions, and therefore those are the proprietary part of the source code. And therefore, in this case, if you are having this sort of encroachment by governments, then it means you may also be letting go of this proprietary information that is embedded in the code and therefore disrupt the very business model upon which these businesses are based. So this is a challenge that therefore talks about taking away the proprietary rights of the creators of software through, of course, the government's instigation. That's the first thing that is worth noting. And therefore, the idea of governments having to oblige companies to divulge the proprietary source code, it may actually be seen as breach of intellectual property rights. The last slide that really I think is important, that then rounds up everything, is that particularly the last point that I've just made to say this may be breach of IP, rights of the owners of this source code. Under the TRIPS agreement, Article 10.1, and TRIPS agreement being the WTO agreement on trade-related intellectual property rights, computer programs, which then include source code, are protected. Meaning, if you own source code today, under this TRIPS Article 10.1, you are given a right in the sense that you may not be obliged to disclose your code, at least for reasons other than those that have to do with public policy objective. And therefore, it is copyright protected. I think from this, you can therefore see that there's now an issue of a tension that is arising, because if the new generation trade agreements, particularly those that are covering digital trade, are coming up with standards such as saying you should, governments are free to request companies to disclose the source code, then that would be in breach of TRIPS Article 10.1. But at the same time, think about the example that I gave, whereby there are inherent injustices that are inbuilt within the source codes, where they can distinguish people on the basis of their ethnicity or on the basis of their race. And therefore, on that basis, if you say you do not allow governments to encroach on these IPs or the source code to get into the heart of how the algorithms are set up in terms of the instructions that they give, it also means on the other side of the spectrum, and I'm trying to give a two-way argument here, If you don't do that, it means, again, you are allowing for algorithms to have these inherent injustices within them. And that's something that I think it is worth noting, the clash between the need to basically allow the innovations of this source code, but at the same time ensuring that the public policy related aspects are actually covered. So there is this challenge that is basically arising. That's the point that I wanted to make. The second point is that if you also have the mandatory disclosure of source code, and then again, the government requiring companies to disclose the source code, then also it means that the trade secrets, which are allowed under TRIPS agreement for countries to protect their secrets, you force them actually to undo commitments that they have under the TRIPS agreement. So literally, what is actually happening here at the moment is that the variable ways in which governments are approaching whether or not source code has to be disclosed or not, it is actually also indirectly a renegotiation of the terms that are provided for under TRIPS agreement. And I think this is extremely important. The last point here is that if then you look at how the licensing happens in the area of intellectual property, you have open source licenses. And therefore, if then again, looking at it from another conflictual point of view, if you say that you want to prohibit mandatory governmental access to source code, also it means you are saying that you are overriding what has been open source by origin. And this is an issue that I think it is worth considering. And there's also other provisions that we see in digital trade protocols and digital trade agreements whereby countries are seeking to foster interoperability. However, if interoperability of softwares and therefore source codes, it is actually mandatory, also the same issues that are coming up here whereby you are taking away the proprietary rights of those who created and came up with these innovations, and again, of course, taking away their IP rights. So what I'm saying, therefore, is that there is a tension between, on one side, the need to make sure that there's protection of IP. I think there's feedback. I can hear the French feedback. But let me say this, that all that I'm saying is that the message that I'm trying to pass across is that there is this tension of the need to protect public policy objectives on one side, but at the same time, that actually is in direct tension with also the need to protect intellectual property rights of individuals. The only thing that seems to be a challenge, again, in this context is that some governments may require disclosure of the source code, not for the purposes of protecting public policy objectives. It may be actually they are seeking technology transfer. And this is where there is a challenge that is actually arising, whereby you mandate a company. Imagine if you want to come up with your own Facebook, and then you tell Facebook to say, for you to offer services in my jurisdiction, I need to have your source code, and therefore you take the Facebook source code, and you'll get people in your own country to develop their own platforms. So these are where the challenges are actually arising, and therefore we are in a very, I think, a slippery slope whereby we have the conflict of norms that are arising. At the same time, these may actually lead to the stifling of innovation. I'm not going to give you any form of resolutions. I think I'll hear from the floor the questions, and then again, we probably can find out maybe how can we resolve some of these issues. Thank you very much, James.
Thank you very much, Tsotetsi, for that interesting and thought-provoking presentation. You have raised quite a number of interesting issues. And I believe the participants that are on the floor have quite a number of questions that they would wish to floor. But my proposal is that we go to the next panelist, and then we'll throw questions after the next panelist. Because what I noted, the next panelist, although goes a bit to traditional knowledge, but he also brings in aspects of digital trade. So with your indulgence, I would like to call upon our next distinguished panelist, Patrick Annam, Patrick Anam is an advocate of the High Court of Kenya. He's also an alumni of TRAPCA. He is a trade policy analyst working with Development Reimagine. But also, other than that, he has research interests in the area of trading services, intellectual property, and indeed regional integration. Welcome to give us your thoughts on traditional knowledge and digital trade. And then after your presentation, we'll have a block of questions for the two of you. Before then, I invite Dr. Stephanie as well as Kanda.
Okay. Thank you, James. I was trying to share my slide, but I think it's a bit disabled, but I can begin nevertheless.
Okay, so let me ask those that we make you a host, then you can share your slides. Jack, can we make Patrick a co-host so that he can share the slides? Yes, you can go ahead.
Can they be seen?
We can see them, yes.
Okay, thank you. Thanks, James, and thanks, Makong and the organizers. I think Makong has delved into one of his favorite subjects so eloquently. So mine is just to discuss what I propose to discuss is on traditional knowledge, and so I'll segue into it and also link it with a bit of digital trade. So basically, I mean, the theme around this talk is today on the role of women in IP. And I think just before this session, I was seeing some interesting data by WTO's DG, basically saying that women have contributed to more or less 13% of IP filings between 1999 and the year 2020. But when you look at it critically, what the data presents is more or less the bigger picture. But what I want to talk about is what basically is rampant on the continent. So that is the fact that majority of traders on the continent are SME based, and secondly that women have been very instrumental in holding some of this important knowledge in form of traditional knowledge. So you're talking about traditional medicine, you're talking about traditional know-how, you're talking about traditional seedlings and seed systems, as well as interestingly traditional brew and the brewing methodologies. And so what I looked at is when you look at the IP regime at the multilateral level, with that background, is to say that the Paris Convention, as well as the WIPO Convention and the TRIPS Agreement, did not in their design have intention to protect traditional knowledge. So this protection is a new thinking. And I think this is purely because some of these discussions that happen at the Uruguay and these other forums are happening from a Eurocentric point of view. But here we are, so that when you look at it critically, therefore, you see that we are talking about the traditional IP laws, rules, copyright, patent, trademarks, GI, and aspects like layout designs, but not traditional knowledge, which is very critical. And so it's when you look at also the declarations at Doha, you find that there were mentions of the need to reform this kind of approach so that traditional knowledge can be made to be part of this intellectual property discussion. And so as I go through these other slides, you'll be able to see why I'm coming up with it. So I've already mentioned the importance of it, and that because most of it has not been addressed, especially by the African governments, as a trade aspect, so that traditional knowledge has largely been seen as something done by folks in the rural areas, etc. You have to look at it critically. There's a lot of importance in it in terms of being a trade enabler. And so, having looked at the multilateral stage in terms of IP regimes, you also need to look at the the regimes of IPR at the regional levels, the regional trade agreements, and principally the recently completed AFCDA protocol on intellectual property rights. And so what I noticed in that protocol is it takes a different approach, and therefore it develops from what TRIPS left this discussion, and essentially incorporates traditional knowledge and traditional cultural folklore as well as genetic resources in it. That's a very critical point I wanted to make. And then secondly is that it does also adopt the sui generis system of protection, thereby meaning it goes beyond what was customarily protected. So again, that's looking at it from the point of view that this is the bane of Africa's rural folks, who are essentially supposed to be beneficiaries of trade. This approach by the protocol takes it a little bit further, which is important. And I think it emphasizes the fact that RTAs essentially are supposed to be more ambitious than just the traditional agreements at the WTO level. And so that is a plus for the protocol. As to whether there'll be protections at the national level, depending on what the protocol recommends, is a story for which we can revisit on another day. And then secondly, also the protocol talks of other regimes. So it therefore incorporates or expects that Africa already has other regimes. And I think that Dr. Chikuti mentioned about OAPI as well as ARIPO. These are two institutions which are critical on Africa. One of the protocols is the ARIPO's protocol, which went ahead and clarified traditional knowledge as well as folklores, and basically emphasize their importance in terms of medicinal value, medical knowledge, etc. So to the extent that these regimes are still on the continent, and therefore because AFCFTA at a continental level has discussed traditional knowledge, it's important that there be a bit of harmonization. And so closing gender gaps, in my view, in terms of digital divide, means that the importance of traditional knowledge must be brought in the conversation. I mean, the rural folks, the rural women who are able to participate in this kind of artistry, which are protected now under the protocol, are supposed to be elevated, because that's the only way that trade can be, Africa can reap from trade, as opposed to just looking at IP from the capitalistic point of view, which of course is controlled by the multinational enterprises. So again, I've mentioned about the statistics, and again, the fact is that Africa is SME based, and when you look at the real traders who should be affected by IP rules, they are informal traders, and so that is why to me there should be emphasis on traditional knowledge, on folklore, and there should be also emphasis on how digitalization of trade, especially on the continent, can take advantage of this aspect that is coming out from these traditional knowledge hubs. So that, for instance, how do these craftspeople take their wares across the countries? Number one, and then secondly, how do we elevate standards so that you're able to have standards that we can use to make these goods tradable or these services tradable? So that is the key point I wanted to put across with this slide. And then the last aspect I wanted to mention is that, of course, IP, both at the multilateral level as well as the regional level, has a lot of leeway for national governments, so that you are expected to expand your rules, your IP rules beyond what is already provided for. However, in my view and reading, as some of the African countries' approaches to traditional knowledge, especially, as is not being beneficial to what I think can be what's important, what is a very important aspect of trade on the continent. So these are in two aspects. The first aspect is there are some national legislations on the continent which essentially have been designed to outlaw somewhat traditional knowledge products, things like illicit, things like traditional brews, for instance, so that in some countries you find them being referred to as illicit, yet these are, things which were able to be brewed or be produced, ages ago. And so the thing that needs to be done, as opposed to making them illicit, is, in my view, to, African countries working on standards collectively, and creation of also regional hubs, and creation of value chains, and so that these things are able to be, be tradable, as opposed to being just reduced to being illicit, because the term illicit attracts enforcers, and therefore it destroys the whole livelihood of people who are dependent on some of these products. Then the second aspect is on the emergence of agricultural laws, especially in certain parts of Africa. These laws have, for instance, are outlawing carrying of traditional seed propagation system, so that in certain countries, there's a country I will not mention here, but there's a law in agricultural legislation that forces you to get a license from the government for you to carry, a propagated seed from one village to the other. I mean, this has a lot of implication on food systems, food security, as well as on trade. And you see, some of these designs were there before, and they were being relied on to produce more on agriculture, etc. So those two aspects, I think, in my view, could be barriers if they're not looked at critically. And so with that, I think the key point I wanted to mention is that this is a new development, and because Africa through the FCFTA has gone ahead to make it part of a regulation through the protocol, we need to take the conversation forward. And in terms of digital trade, I mean, once this is taken forward and there's enabling of cross-border trade, then it's possible to have this traditional knowledge and seedling systems be tradable across the borders. Yeah, thank you.
Thank you very much, Patrick, for that. I was fascinated when you started with highlighting the issue of statistics of IP filings that can be attributed to women. And one would then go a step further and say, based on where you started from, if we look at those statistics and then we think about women on the African continent, what percentage would one say out of that little share would be attributed to African women? The question that I want to pose to you as I invite the audience to ask questions to both you and Tsotetsi is, if we think about the African continent, especially we're looking at women, we know most women, it's either they are working as SMEs or whatever they are working on is sort of on a small scale. And if we look at the horizon of intellectual property, if we look at the intellectual property, types of intellectual property rights, which ones would we say present low-hanging fruits for women in order to advance themselves so that they can protect whatever it is that they have come up with and they are selling? That's the first thing. I also noted you mentioned challenges relating to restriction on traditional knowledge, and you gave an example of traditional blues being considered illicit. How then do we marry with health-related issues or concerns or SPS? Then to Makong, as you think about that, Patrick, and indeed, like I said, also I'll open to the floor. How do we deal with challenges of accountability and transparency as far as algorithms are concerned? And then you mentioned the fact that within the TRIPS agreement, source codes can be protected by provisions on trade secrets. And considering that in the TRIPS agreement, governments, by way of exception, may go ahead and not protect some of the trade secrets if it is necessary for protection of the public. Wouldn't we say then, or then how can that be used in light of the new FTAs that are dealing with digital trade, that are calling for disclosure of this particular source code? Would that present an entry point, or there is need for something more? So either Makong or Patrick, you can start.
Thank you,
yeah, thank you.
Thank you, James. And maybe let me give Patrick a moment to think about your difficult questions and go straight to the question that you asked about the challenges concerning accountability as well as transparency. I think what is important is that we do not want to stifle innovation. That's quite critical. But at the same time, we do not want to have a regime that is running amok where human rights of individuals may even be trampled upon. And therefore, I think the practice has always been there should be industry-based standards. Because when you have industry-based standards, the industry itself, so you can imagine those who are in social media, they're able to come up with certain basic rules that they should actually abide by as an industry. But again, what is also key here, and going into your second question concerning the public policy protection, we know that it's a given that we have the exceptions even under the World Trade Organization. So that means if there is a legitimate public concern that needs to be addressed, then yes, you can actually, as a government, go ahead and then act in a way that can protect the public. Where the challenge arises, and there's a different story also attached to this, is when now these mandatory disclosures are basically fomented for the purposes of having access to technology, proprietary technology. This is where an issue comes in. Now, of course, if we think about it from the point of view, imagine if we think about the African software producers and a lot of young people and companies, that the startups in Nigeria, for example, that are doing wonders in this particular area, including in fintechs. Imagine if there was to be a mandatory disclosure of a fintech software. Definitely, that particular individual will lose business if such disclosures are done in such a way that information gathered would be given to potential businesses or even competitors. So again, that will be killing the businesses. But however, where we have a big challenge in terms of coming up with these rules, if you recall, the LDCs under the World Trade Organization, particularly under the TRIPS negotiations, they've been seeking for technology transfer. And therefore, there is a tension there because the LDCs under the World Trade Organization, when they seek for technology transfer, they look at it from the perspective of the advanced countries and not from the perspective of the LDCs or other developing countries themselves. So again, you have these different tensions, but for all intents and purposes, the most important thing in a divider is to make a distinction between the public policy related objectives as well as the technology transfer related objectives. So I think in a way we should, as much as we can, not stifle technology and not force these developers to provide their hard-end technologies for free. Thank you very much.
Thank you very much, Tsotetsi, for that. Patrick?
Yes, thanks, James. So I think, yeah, this quite difficult question. But what I would say is that one of the low-hanging fruits, if you ask me, is the fact that, I mean, we are talking about digital trade here. And I mean, traditional knowledge products and services can be traded across the continent if that information is there, it's collected properly, and it's shared on the digital platforms. That's one of the sort of my quick take on that. And I think the other aspect, of course, is linking some of this traditional knowledge aspect to the geographical indications regime, which also to me can be one of the quick wins that this can go through. But I think it all depends on firstly what are the different national priorities, which mostly on the continent is usually at variance. But I think it can be started, let's say at regional level. So let's say we are talking about ESC. We have those cross-border traders. I mean, we know what is traded across from Tanzania to Kenya and Uganda, Rwanda, etc. So that information using digital platforms is one of the ways that can start that, of course, organically. Then we proceed forward. And then secondly, as regards the issue of standards, yeah, of course, it's a difficult one as well. But my point was that if you wholesomely illegitimize trade on some of these products which were there, like traditional herbs, etc., for ages, has been there for ages, you therefore lose on the chance to enable the traders or the specialists in this area to advance this. Rather, I mean, what should be happening instead of the blanket illegitimization, in my view, is for governments to invest in research, and most of these countries have research institutions, and to most importantly put funds in institutions, and also offer a trade finance to enable the traders be able to meet this standard. And then also secondly, of course, is to ensure that when you start trading in these products or services, I mean, in this product, you primarily target the continent, and you are looking at intra-African trade, because I mean, as a way to avoid hitting those hard standards that are set by the West and etc. I think that should be my take on those questions. Yeah.
Thank you very much. You have dealt with them thoroughly, and indeed, on the floor there is one of our colleagues, Regan. What he says is that spot on. These traditional blues enabled some of us to pay school fees, but maybe the issue would be, that's from him, if we strengthen the standard, then indeed, as Patrick is saying, this could be protected using geographical indicators, and therefore that may create employment and more benefit for women. So then there are two questions, and then I'll move on to the next set of panelists. One from Patrick, your namesake, Patrick Chinguo. He says, considering that as Africans, we like to share our traditional knowledge, how then do we protect it as a means of trade? And then the next question, in essence, talks about the legal implications of intellectual property with regards to traditional medicines or elements of traditional herbs held under multinational corporations, as opposed to when it is used as part and parcel of indigenous people or individual cultures. An example is given of aloe vera, to say this plant, our parents have used it for generations to treat various ailments. Now that it is put in toothpaste, which, for instance, Unilever holds an IP towards. So how do we address this issue? So both Patrick and Makong, you are welcome to dive in these two questions.
I don't know, James, maybe I should let Patrick take his questions, but I saw there was also another question as to what I meant in in terms of one of the statements that I had, namely being caught between the devil and the deep blue sea.
Yes.
And by that, what I mean is that we are in a unique moment where Africa, to leapfrog technology, is the promise that can allow us to do so. And like I mentioned, as we know, there's an explosion of software development in countries like Nigeria, in countries like Kenya, Rwanda, and others that are really focusing on these technologies. So therefore, the issue is, if we are talking about the mandatory disclosures of the basis on which the foundation of this particular softwares, what are we saying? Are we saying that the hard-earned efforts, the hard-earned labor of these young people, and mostly young people, it has to be thrown out into the air because government can ask them to open up their source code without no form of some sort of parameters against which they would do that? So that is one side of the argument. The other side of the argument is to say, are we throwing away the LDCs, least developed countries agenda that seeks for the global north to actually transfer technology? How do you square that up? So the issue is about the policy conflict that actually arises in our context. And of course, the issue of course here is to say that, is it possible that we think about a differentiated treatment depending on where certain businesses are coming from? So you could have a business that comes from the global north, of which the agenda on the transfer of technology may arise, but maybe you may not request the same when it comes to someone who comes from indigent countries, such as we have in the continent. So I thought that I should make that particular clarification, and otherwise I hand over to Patrick. Thank you.
Thanks, Mahong, and thanks, James, and thanks the participants for the great questions. Yeah, so I'll start with the one for how to convert this into trade, given traditional knowledge is generally shareable. So I think earlier on I was conversing with a colleague, and he was mentioning to me that the big question has been whether Africa actually values IP. And I think to the extent that we are seeing the importance of how IP is doing for others elsewhere, increasingly it will be possible for Africans to also value IP. And of course, sharing is a traditional, I mean, it's African really. So, but I think one of the ways of which that can be converted beneficially is, for instance, if you look at a traditional knowledge or a product thereof of a certain geographical location, let's say the Maasai, for instance, in Kenya, or some community in down south, then what becomes, it becomes a communal project. So therefore the product is communally owned. Therefore it means if it is taken to a level higher and trade emanates from it, the benefits are of course shareable communally. So different countries already have some of these communal ownership legislations, but I think this is a point at which countries need to think through of ways to make this at least beneficial, but also at the same time having reliance to, I mean, having consideration to the African culture of sharing. So that would be my quick take on it. The second question is regarding multinationals who are already engaged in some of these aspects, products like aloe vera, etc. I think, of course, it boils down to the contents of the Convention on Biodiversity, and I think we also know there's a lot of issues concerning some of the products that have been essentially cutted away and patented elsewhere without the knowledge of the originators or the communities where they're coming from. I mean, if you look at the genes fading aspects that is used all over the place, especially in the US, it emanates from some tree in somewhere in the Rift Valley in Kenya. So, but it is not patented in Kenya, as you can imagine. So I think it's a wake-up call. But I would not say all is lost. I would say there are regimes like the conventional biodiversity which can be looked at. There are regimes that we can think through of how to really apply them to deal with this menace of biopiracy. But I think the fact that they are being used elsewhere and does not mean that if Africa still has others which have potential and which have not been exploited in that funny way, then I think something can be done. And I think this is where now government policies come into place. I mean, most of our governments do not really see IP as trade, they just look at it in a silo. So that kind of thinking may change, but I think it will take time. But these conversations such as this are important towards advancing those arguments and that development. Thank you.
Thank you very much, Patrick. I've seen Dr. Chekoti, you've had your hand up for a while. I was going to now go to the next set of presenters, but let me give you a chance.
Thank you so much, James, and thank you, colleagues. I think very interesting discussions and arguments. Makong actually raised very important issues, and I think that's where you have at times what you describe as a catch-22 for African governments from a policy perspective. And I was thinking, yeah, I mean, in the last elaboration, Makong actually brought out the main issue, that kind of differentiation. But I was thinking there is also a political economy dimension, because then you're dealing with policy, it's about interests, it's about stakeholders, and then you're looking at some of the stakeholders that really have a lot of influence. If you're looking at multinationals, a number of times they find and they push their way around things. So probably bringing up a political economic dimension to the argument would allow us to bring out some of the things. Then for Patrick, I also find something very interesting, and I think for me, what catches my attention is the issue of
Sorry, Dr. Chekoti, you're muted, unmute.
Thought I had unmuted, sorry.
Yeah, no, it's okay.
Is that from the beginning?
No. Just now, I think it just went.
Okay, so I was saying for Patrick, the issue of seed propagation traditionally, and I think there's a very serious issue from an agricultural point of view. And I think in most of the African countries, what is actually emerging is the traditional seeds and the way of propagating those seeds among a number of the farmers is fast disappearing. Yeah, and of course, it's being replaced by hybrid seeds and so forth. And it won't take long before they have total no control. And you can just imagine the ramifications in terms of where you want to look at it in terms of gender and so forth, and probably dependence on multinationals is a very big issue. And of course, you can also connect that to the traditional pharmaceutical. And I mean, we saw it with the COVID, and the number of entities that actually came up with the very interesting concoctions, herbal concoctions. But at what extent do we take that to the next level so that then we have products actually that are protected, they are patented, and so forth, is an issue. So for me, one thing that comes into my mind is maybe one way forward is thinking about a development of an IP ecosystem that links researchers, probably, and the number of the institutions, maybe universities and so forth, and other research institutions dealing with a number of these issues, linking with the industry. That creates an environment that promotes coordination. Patrick brought out the main issue to do with the communities. But you see, communities, unless they are coordinated, there's something that brings them together, it will be very difficult to take it to the next level. So we have a coordination issue. And maybe it could start by focusing on the link between knowledge creators and the industry, having some kind of an ecosystem. Probably think about a framework. And in that way, we could probably have something that could actually work. Just my thinking. Thank you.
Thank you very much for that, Dr. Chekoti. You are raising quite important issues, which I believe also we should be able to take them up after we've heard from the next set of presenters. For those just joining, they are translation both into French and into English. We will now be moving to our next presenter who will be presenting in French. I would like to call upon Dr. Stephanie Mbom, who is an intellectual property attorney and founder of an intellectual property rights law firm, GAD Consultants, and who is also a senior lecturer at the University of Douala in Cameroon, and who is also an adjunct faculty member here at TRapca. Dr. Stephanie will be presenting on the topic, the digital world, an opportunity and a risk for intellectual property rights owners. Stephanie, over to you, and you're welcome.
Oui, merci à James de me passer la parole en tant que modérateur. Et je commencerai par dire que j'ai beaucoup apprécié les précédentes présentations qu'ont faites mes copanélistes.
Made by my co-panelists, and it helps set the pace so we could better present the topics for the International Women's Day. So during the first presentation, I saw that the previous ways in which intellectual property in Africa was presented as a risk, but as the world evolves, we should equally appreciate intellectual property. It's true that 10 years ago or more, international debates were more on economic development and intellectual property, not forgetting social development, and were more and more on the aspects of equilibrium which were integrated in the profession of intellectual property between interest and those in charge of the law, and also those who use the law. But as I was saying, we are in a digital world. For Africa, in charge of the use of intellectual property. For my topic, I will say it in English: digital war and opportunities, and the risk for the owners of intellectual property rights. And in French, it is le monde
pour les détenteurs de droits de propriété intellectuelle. C'est vrai que le concept de village planétaire, il est de plus en plus caractérisé dans le contexte digital. À travers les technologies de l'information et de la communication, on peut avoir accès très rapidement au monde entier pour la circulation, non seulement des informations, mais également pour l'information sur des produits ou services commerciaux. En cela, c'est vraiment un vaste marché ou une vaste plateforme où il n'y a plus de limites géographiques et où qu'on soit dans un coin le plus reculé d'Afrique, dès lors que nous avons une connexion Internet, on peut avoir accès à un public très large. Et en cela, c'est devenu un peu le moyen fondamental d'échange par lequel on communique, par lequel également on commercialise des produits ou des services, ou alors on communique sur les produits ou les services. Donc, c'est une plateforme commerciale. Et pour les pays africains qui ont des impératifs aussi de développement économique et social, le digital est un vaste marché, est un vaste auditoire où on peut se faire entendre, où on peut échanger sur des biens commerciaux.
Where we can exchange on commercial goods, especially on property, intellectual property rights. Through the empowerment of women, we can have a kind of emergence for creativity, innovation in the domain of technology communication. We can also realize that in the domains of the different visions of application like Microsoft, which are getting the more interested in creativity in the different softwares, like youth who are starting with the startups. It becomes a real asset for Africa, which has to value in the framework of the digital world, which is equally a commercial opportunity. And we also realize that youths are at the front lines of this application or the exploitation of this digital world in order to valorize their scientific, artistic, or ecological use, especially in the cinema world. That is where the importance of our subject or our topic comes from. It is undeniably an opportunity. And the characteristics of this property, intellectual property right, is to create an exclusive right for creators from Africa in terms of scientific or all sorts. The digital world can be an opportunity. Let's take the case of companies. We are in the backdrop against the backdrop of ZLECAf, which is a free trade area for the African continent. The digital world can be a place where African companies can communicate on their products through different platforms like internet and other social media networks. And even in terms of research and innovation, we need information, especially as far as these degrees are concerned, the state of the technique, so that given that innovation is for the protection of innovation. And how do we get access to the data which enable us to? It is great information on the databases that exist. It's about 20 years, 30 years, let's say. All these means were not accessible because they were archaic. You had to go to places to carry out research on the physical databases of countries, and you could have a number of information. And so it is easier from a computer for an African researcher to have access to data, world database and all databases. And so the researcher is in a condition where he will not need to displace himself, where he will have to go into structures to have this scientific data. He has everything before him, before his computer, to be able to have the database. And this helps to improve on the capacity of the innovation in Africa. And with this, we can see some sort of democracy in the whole process. As I was saying a while ago, that the capitals of Europeans are now on African startups. And now we now gain interest in African creativity from the scientific databases, all these which are all these services that are free for exploitation, are all opportunities for creators to leverage on, given that they can have the information that will enable them to have creations that can help these Western countries. And that is what we realize in countries like Nigeria and other Western African countries in Nigeria, where people invest in the and maybe in the years to come, Africa will be a center for commerce, and this can help. And thanks to this opening that these databases give way to, we equally see this the success of some African artists. From YouTube, for instance, some artists are easily known, and in just some minutes, they can be able to have They can have tens of millions of followers from their artistic productions, and it is from there that they put to value their artistic creation through performances and many other artistic works. Some of those that we know, all this was done through the digital world and through the platforms where these musical works were spread. It is also a means to valorize, because you do not just have to have an intellectual property, you have to transform it in money, permitting states, enabling states to have the means to increase their basis, to enable employment to be created. And so valorizing is also a very important point. The case with African startups. And I'll take the example of Cameroon. We have young startups who do well, but who need capital through these digital platforms. You do not even know through internet who is taking place in the financial mobilization of these resources for you to develop or to set up this creation, something that was very impossible when this digital world was not yet democratized. And so for the youth, we also have this ability of raising more than hundreds of millions of dollars through the digital world.
D'activités innovantes qu'est le
or innovation activities, what we call participative funding. These are therefore the opportunities that this digital world offers for us. And it is an opportunity because I think that the most difficult thing for us to carry out such activities is for us to have a technical framework, materials, but there is also scientific information and also access to scientific information. And so it's an opportunity and likewise a risk because it has to do with the interest of the intellectual property. Given that the intellectual property has as role to be reserved by the market. And in the digital world,
libéralisation ou cette liberté digitale,
this liberalization
de droits de propriété intellectuelle, notamment à travers justement le phénomène connu de contrefaçon, qui devient même une industrie mondiale. Et il faut dire que la création africaine en souffre.
And we have to acknowledge the fact that African creation is really doing well. Let's take the example of the artistic world or artisanal work, where you have pearls, we have sandals. We know that they are of good quality because they are made from special materials. But there are also fake ones coming from another huge production. And we just need to go to a special page.
Notamment ces sandales, puisqu'on les vend ici au Cameroun à peut-être 3 fois le prix d'achat en Tanzanie, mais ils les reproduisent eux par millions. Et là, ça devient une menace pour les créateurs d'innovation ou alors de création artistique africains.
And so it becomes something that needs courage for African creators.
Mais il y a également le problème des données. Parce que les données,
we also have a problem of data because data equally circulate through the digital world, and the first presenter also lay emphasis of that. We have a problem of data security. We have not always have the appropriate means to protect our inventors and innovators. And that is where we underscore that they have an important role to play. The state has other priorities, be it the priority for the fight of their needs or access to health, fundamental needs. They don't really have a budget to put in place a system where they could benefit in order to protect all these innovations hailing from Africa. And I also want to raise awareness.
Des créateurs qui sont bien avertis sur les questions de propriété intellectuelle. Cette proportion n'est pas très... sur une échelle grande, elle peut être considérée comme infime. Et il manque parfois des moyens. Et en cela, justement, le cadre multilatéral est un cadre qui permet de résoudre, par exemple, ces problèmes. Il existe justement au niveau multilatéral, notamment au niveau de l'OMPI, avec le programme de l'OMPI pour le développement, des moyens, notamment pour renforcer les capacités internes. Il y a certains pays, par exemple comme le Japon, qui financent les activités d'innovation en Afrique. Donc, il se pose un problème justement de moyens de sécurisation des intérêts de l'Afrique dans le monde digital, face aux risques que présente l'exploitation ou alors la diffusion des créations originaires d'Afrique. Et ce problème se pose autant pour les hommes que pour les femmes. C'est vrai que nous avons une
True that we today have a day that is given to women, that is consecrated for women in the context of the World Intellectual Property Day. But some actions also need to be channeled in this domain on questions, so that on question on gender as well, because gender questions are issues that international organizations are interested in. Just as the Sustainable Development Goals
SDGs
reflect it today, and they are trying to take into account, they're trying to integrate the gender aspect. And these are bridges, these are occasions, opportunities in terms of women's content creation in the domain of science and technology and innovation
and technology
and art in Africa,
in arts
to actually
in
get
Africa,
some capacity building
and reinforce capacities.
And this can be done through these international institutions, and why not through the AFDCA that is trying to set up a system so that women might really get well informed on the different means that are available for a follow-up on international on intellectual property. And the states, the governments are also thinking of the ways to set up a
better security for the rights of IPs in Africa, and also on numerical platforms, on digital platforms. In a nutshell, this is what I would like to present. And I would also like to thank the organizers of this webinar. Thank you very much for your keen attention.
Merci beaucoup, Madame. At this point,
Thank you very much, ma'am.
I would like to call the next presenters before we go ahead to invite comments and questions from the floor. So we will be going to our next presenter, Kanda. Kanda is an alumni of TRapca. He has done a lot in terms of intellectual property rights. He is currently a project manager as well as a director general in an institution that is dealing with intellectual property rights issues. And we are excited to hear his views, as he is also going to be presenting on IP from a digital trade perspective and bringing in the aspects of how women are impacted. Kanda, over to you.
Merci beaucoup. Merci à Monsieur James de m'avoir donné la parole. À travers Monsieur James, je remercie TRapca de nous avoir associés à ce webinaire. Et je n'arrive pas à partager mon écran, mais je ne sais pas si Le hôte peut nous aider à partager l'écran. L'autre peut nous aider à partager l'écran.
Jack, can we make him a co-host so that he can share his slides?
Yes. D'accord, OK, now it's OK. OK, merci beaucoup. Donc, ma communication. Donc, ma communication intitulée Propriété intellectuelle, e-commerce et dynamique de créativité et d'innovation.
Is intellectual property, e-commerce,
Donc,
and
le plan
creative
de
dynamism for
notre
women.
communication se présente ainsi.
It is worth noting that our presentation.
Excusez-moi.
I'm sorry.
Donc, je reviens un peu. Le plan de notre présentation se présente ainsi. Nous rentrons.
As I was saying, I would like to talk about the plan of our presentation. We are going to talk on 4 main topics: the importance of IP in commerce, the difficulties of e-commerce, the participation of women in the IP system, and 4, we will talk about how to tackle obstacles. So intellectual property, as we earlier said, it's the creativity of men and its capacity to do that. And it is putting men at the center of development. As a system of development, it's a factor which helps innovation, creativity, and investment. So intellectual property, amidst all what is seen as jurisdiction, it's an important economic tool for the growth of economy in the world, and it helped a lot of countries develop. And it is also known as the knowledge of economy. It is used as the means to tackle all exploitations that are not authorized. These are main tools for communication because people can use it for communication to sell their products through their mark and other marks that we know that help distinguish the products of your company. So some companies use it to distinguish their products and to launch and for some companies to launch their products, they use this for their products to be sold in the market. So it is important in order to sell a particular product. It is also a tool which people use for the effective management of their enterprises, and also to tackle their competitors. And it could help also owners could use the law of competence in order to have finance or fundings, because amidst creation, people who are interested to invest will actually invest in innovation, and in a short term, they will have a return, and the owner of the rights have the possibility to change things. So the African context of IP and e-commerce, now we have 2 concepts that regularizes IP in Africa with the we have OAIP and ARIPO, which is the African Regional Intellectual Property with the
système, nous avons également certains pays nationaux.
With the Lusaka Agreement, and also we have national countries, or should I say countries in Africa that have their own IPs. And we have, for example, Nigeria and South Africa. Also, we have IPs protocol ongoing negotiations for the ASCFTA. The e-commerce materializes itself at times through the rights of the owner, because the fact that these are e-materials, that is, they are electronic, so they are mostly protected by so when it comes to streaming music, the music we listen online, it is also done through platforms where people put their music. The music we listen to is also known as e-commerce, and also this innovation is a creation which is protected by the rights of the owner. And amidst this, we also have other IPs that intervenes when it comes to e-commerce, and it's also as the mark and the name of the product. So then, because the enterprise that creates this gives the commercial name of its company or a main product that he is selling. So for the difficulties of the challenges of e-commerce in Africa, we have as challenges online payments. Today, we have what we call vintage, and there are a lot of apps that are developed through this in order to transfer money online. And we also have apps that are developed in order to pay online. But in Africa, we have security issues when it comes to payment, and also how to safeguard this information and also the information of the consumers. So we have these main challenges which e-commerce faces in Africa. Now, how women are meant to participate in the IP system. So we have disparities between men and women. In 2022, 16.5% are female, and the treaties in Africa says that we have just 16.5% that invent this, and they are only women. And according to the United Nations Organization, 7% of those who realize this are women, and 50% are just women.
It has revealed that works created by women was sold at a cheaper price than products that were made by men. So these are some preconceptions that do not help to give the right value to works that are to products that are created by women, and especially for artistical and literary works. I just gave some statistics, but it's because here we are more talking about industrial property, and there are some administrative steps that have to be followed. And yet we need to have some more information in order to be able to give a proper appreciation to women's contribution to IP. When we go into artistic and literary work where we have direct where IP is acquired easily, it is really hard to value this to value the participation of women into the IP system. It is true that ladies are less innovative. It is true. However, in Africa, there are some areas where women are doing quite well. Madam Godem just talked about handicraft, and where especially the textile, where women are doing a very good job. I like to give the example of Nana Benz in Togo and Benin. These are women that are the ones that are creating their loincloth, and they want to just come in Africa to market it. So everything depends on the model that is used. We also have a company that they have. We also have the platform where they sell their fabrics, but usually because they don't have the information, they are not able to protect their products, and they are subject to the counterfeiting that is from China, because the products because the Chinese products are cheaper, and because women that are in trade are into the informal sector, so they do not have what it takes to secure their creations. some obstacles that we think it's important to overcome to ease innovation and creativity for women is, first of all, we need to foster technical and technological women's innovation by encouraging young girls to study in sciences, techniques, and technology and engineering. We need to fight stereotypes, preconceived ideas that limit women to a certain type of trade. Also, we need to set up some policies that allow women to merge together to be able to manage both their professional life and their family life. We're also talking about sensitization awareness campaigns sometimes, but we do not identify the areas that need to be highlighted, where the information needs to be shared. Here we have identified some areas where women are doing well. If we really want to make sure we reach out to women on intellectual property, the awareness has to be focused on the people that are in this line of trade, because in this line of trade we have a lot more women. We also need to encourage women that create products. We need to encourage them. And I think this is where I will stop. If you have some questions for me, I'll be happy to extend my thoughts over them. Thank you very much for your attention.
Merci beaucoup, Roland.
Thank you very much
for that elaborate presentation. I note, yes, we are against time, but I would ask the indulgence of the participants that maybe we do a bit of 5 to 7 minutes so that we can clarify on some of the issues, considering that there are questions on the platform. One question that is on the platform, I think it's to both Dr. Stephanie and Kanda, is how will intellectual property protection work between the AFCFTA IP protocol and the other IP protocols that are existing in some of the regional economic communities that are on the continent, to avoid duplication. But in addition to that, there's also a question from Marianne. Marianne, I would ask you to ask yourself the question, considering that you have asked it in French.
Yes, thank you, James. Hello, everybody. I hope that you can hear me. The last presenter talked about the difficulty of payment concerning e-commerce, and I was saying that majority of those banks operating in our countries are from Europe or USA and so on. So they have the technology for securing the online payment. Why don't they apply it into our countries? Also including the PayPal payment system, which is not present in Africa. Why can't we have access to that kind of technology, which is available, and facilitate our integration into the e-commerce? Thank you.
I suppose as you're thinking about answering those questions, I'm sure you may also wish to talk about the Pan-African payment system that has been established as part and parcel of the AFCFTA. But also, I believe now we are moving into an era where, if, for instance, I look at mobile money, like in this part of Africa, I know someone can transfer money on Airtel Money from Kenya to Zambia, or Kenya to Tanzania, or M-Pesa. So we're moving to some direction. Yes, it's not PayPal, but there are also platforms that as a continent we are developing. So over to you, Dr. Stephanie and Kanda, on the questions. And please, if there are further questions after we have gotten the responses, you're welcome to ask.
D'accord, bon, je vais me lancer à l'eau.
All right, so I think I will get started. Thank you for the questions. I would first like to come back on the first question about securing online payments, the fact that we have international payment systems that are not developed and deployed in Africa today. Well, I think Mr. James just mentioned that we have mobile money. This is an African innovation. I'm proud of saying so. It's an African innovation that is being used today, even outside the continent. So we are really moving at our own space. But as we say, these are challenges. And these are challenges because, today there are stereotypes, many African today, because when you take most of the most of the African people today, they do not have a bank account. So even if the banks use such systems, African people might not benefit from them. But if you go today in remote areas in Africa and remote villages, at least you can see these mobile money systems that are used over and over. So I really think we're moving on at our own pace. And I think that IP will facilitate technology transfer, because since these are innovations that are coming from other country, we as well can have this expertise and improve what we already have. Now, I think there was a question about the CFTCA protocol on existing systems. I think right there, they are just minimums. It's not yet things are not yet harmonized, so to say. It's not one institution for the whole continent. But if let's recall that IP today is a territorial right. When you have when you have law, the territorial law, you will have law, it is proper, it's specific to a territory today. If we take artistic intellectual property today, it doesn't have any border and boundary, but if you take intellectual property, it has some boundaries. So we need some standards that we need to discuss some standards with the AFCFTA to set them up. Thank you very much.
Thank you, Kanda. Dr. Stephanie, if you have, yeah, go ahead.
Je vais revenir sur
I would like to bounce back on the question about the cohesion between the existing agreements in the EFCTA and the existing regional agreements. How will this be done? It's true that it is a relevant question, because the AFCFTA protocol on IP has not yet been adopted, and it's not easy to have access to this protocol. Just some months ago, um, um, just a month ago, that we had a kind of unity with OAP to get into the discussion, so as to ensure that the agreement on IP from AFCFTA should not be a threat on the existing systems within the regional organizations and that are actually operating. So for now, the specialist the AFCFTA specialist will give us more light about that, but we don't really know much about the content of this agreement. And generally, we are expecting the content of the IP agreement from AFCTA to present the different outcomes that have been the different things that have been achieved at a multilateral level in the context of the development program of the World Intellectual Property Organization. And it's my hope that in this agreement that will be implemented, it will be more of a harmonization of different protection policies, but not to threaten existing regional IP systems like the ones that are already in place. So maybe he will give us much more light, but these are issues that are quite relevant, and these are concerns not just for state members of regional organizations, but also the practitioners of the concerned professions, where we are asking, where everyone is wondering whether AFCFTCA will not threaten the operation of existing professions. Will it not lead to a liberalization of services that are linked to IP? Meanwhile, the African states are not yet ready for that. So it's a serious debate because there were some traditional issues that were taken into account, as well as the particular interests of governments. And it's our hope that in the AFCFTA agreement, this issue will be clearly sorted out, because this there is an influence issue that is usually displayed in it, but we really hope that it will run smoothly. So I am waiting on clarifications from the AFCFTA expert. Thank you very much.
Thank you very much, Stephanie. And I think as we wind up, Makong, you've been thrown to the deep end, because what Stephanie is saying is that if you could clarify to the audience the question that had been asked regarding how the AFCFTA protocol and other intellectual property rights protocols already existing on the continents will operate in harmony so that there's no duplication. And I suppose as we go towards that, we would then also go towards closing.
Thank you very much, James, for the question. I think there are very important considerations that we need to make. For those of you who follow the IP regime globally, you very well know the limited contribution of Africa in the development of the IP regimes. For example, earlier on, our colleague Patrick was talking about the WIPO treaties. Recall that those treaties, some of them were created in the very, very early 1900s. And prior to that, and of course, from that point of view, most of the African countries were still even colonies. So the point is, it was not at all in the consideration of those countries that created those treaties to have an African lens and perspective. And for many years, I had the privilege of covering the work of WIPO, and of course the World Trade Organization as well. If you go and look into the proposals of African countries on how the WTO IP reform should be undertaken, it really goes against a lot of some of the principles that you have in the IP regimes. Now, the fact also is that part of what we have in our own regional IP regimes, the existing one, is a replication largely of what comes out of the World Intellectual Property Organization as well as the WTO. Now, this is not to say, and I have to clarify this, this is not to say entirely the whole IP regime is bonkers and therefore of no relevance to us. No, that's not the point. But the point is, part of it, actually a sizable part of it, has not as yet served Africa well. So we have to, in a sense, be very careful in terms of how we characterize what we consider to be the existing regimes, because those regimes, for a fact, African countries are challenging those regimes, including the patents. I would give you an example, and my colleague Patrick spoke about this. Can you believe, for example, there are certain companies in Europe that are basically replicating the Luo culture and using that culture in their fashion? And of course, we've seen the Maasai and others. And again, we know what has happened in terms of some of the genetic materials that had been taken from Botswana. But the IP system as it exists right now, it does not protect all this collective intellectual property of Africans. So when we talk about this, we have to be very careful. Now, coming to the issue of the AFCFTA, I think one of the most critical things we have to be wedded to is that the continent is actually divided, in the sense that the standards that you have in the, for example, the OAPI context are a little bit different from how you have these standards under the ARIPO context. So we have actually adopted different contexts. And therefore, it is important for us to look at IP from a harmonization point of view. That is one. I want to leave you with this one example. Today in the African continent, if you have trademarks and you want to register your trademark, guess what? You have multiple points of registration. And these multiple points of registration are administered under the very same existing IP regimes that we are having. And therefore, it is expensive for businesses because it means you will have, yes, they are territorial, the IPs, but under the trademark regime, what if we actually think of registering IP trademarks once? And that is actually an opportunity that the AFCFTA provides in this example. And I'm not saying that everything about the existing regimes is wrong. Please get me right. But I'm saying there are reforms that we have to be thinking about, in particular, in this example that I'm giving of the trademarks, to make sure that you can only lodge one registration and it applies across the continent, as opposed to you then having to go down to Aripo to register the trademark, and then you also go down to OWAPI to register the trademark. No, I think, again, perhaps this is something that we can agree on, that some of the regimes that we have at the moment may not, of course, not in their entirety, I have to be careful with my words, may not necessarily facilitate trade, and therefore IP becoming a stumbling block as opposed to becoming a facilitator. So I think maybe I should stop there, but I think maybe just to give context to what has been mentioned so far. If there's any other clarification needed, I'll definitely take it up. Thanks, James.
Thank you very much, Makong, for giving us that elaborate explanation regarding how the AFCFTA protocol kind of addresses some of the challenges with the existing conventions, and which is interesting also when you highlight some of the potential benefits of implementation of the FCF protocol on IP. So I'm mindful that we are out of time. People have to move. Before I call upon the head of center to give us a vote of thanks and closing remarks, I would like to request all of us that are online to switch on our videos so that we can take a photo of everyone that participated in this webinar or who is around. Please, let's switch on our cameras so that my colleague Jack can take a snapshot of this particular session. Dr. Chekoti, you can switch on your video. Patrick, is your video on?
Yes, it's on.
Okay. Jack, over to you. So Jack, you let us know when you are done, when you have taken the picture.
Yes, in a minute.
So as Jack is taking the picture, let me take this opportunity to thank our distinguished. Okay, thank you very much, Jack. Let me take this opportunity to thank our distinguished panelists for making your time to give us the various insights that you've given us, considering the importance of intellectual property rights. Indeed, this is an important day in commemoration of intellectual property rights protection. And bringing in the issue of women is very important, considering if you look at most of the small firms that are into trading, you find that women are at the forefront. So let me say thank you to Stephanie, to Kanda, to Patrick, and Tsotetsi for your time. And indeed, also let me thank the distinguished participants that have been with us throughout. Let me thank my colleague Jack and Shailet for making this organization possible. And I would like also to thank the translators for helping us so that all of us could understand what was being said. At this point, let me call upon the head of center to close and give a vote of thanks. Thank you very much.
Thank you so much, James. I think this has been quite interesting, and a number of issues have come up. I think that provides a very rich context for further work. And it is my belief that this is just the beginning, and we should be able to have more of this series so that then we can be able to, bring out the key issues that could be relevant to shape the IP regimes and how we utilize innovation, foster innovation, and maybe help our policymakers, get ideas to take this forward. So thank you everybody for participating, and keep the fire burning as far as these issues are concerned, and keep in touch. Thank you very much. You're most welcome.
Thank you very much, Head of Center, and thank you very much, everyone. Have a good evening. For those where maybe it's just the afternoon starting, enjoy the afternoon. Thank you.
Thank you.
Thank you.